Last week, you mentioned about the possibility of there being a power of attorney in my employment related settlement agreement to bring my directorship to an end. What did you mean by that? I'm Richard Hiron, also known as the Hironator, and I'm an employment law solicitor. So, to begin with, the concern may well be that this is a wide-ranging power of attorney that doesn't just relate to your directorship or your employment. The fear that might be going through your mind is your employer rocking up at some point in the future and saying, okay, you used to be our employee once, you've signed this power of attorney, and this means that we now have control over your property and finances and your health and welfare. That's not what it's aimed at. The limited power of attorney, and I stress the word limited, in a settlement agreement to essentially govern the removal of a director is aimed at that. The removal of a director, whether it's by resignation or otherwise, from a company. It shouldn't be straying into other areas, whether personal or financial. So that limited power of attorney should essentially grant your employer the ability to say to a member of the board of directors, the company secretary, if they're different from the board of directors, a lawyer, an accountant, basically do what needs to be done to ensure that this director's directorship is tied up and comes to an end. Not anything more than that. So, provided that instruction through the power of attorney is completed satisfactorily, that should be the end of the power of attorney as well. I hope that that's cleared up that point. However, in the meantime, if you're finding a settlement agreement hard, bring it to Richard.